The short answer to that is yes. Police are required to get a warrant, so they have the power of the court behind them to make certain searches. But there are a lot of exceptions that have been found in the law the courts have created or they're created by statute. Chief among them are where the police could make a search based upon exigent circumstances. For example, if a house was on fire, the police are allowed to go inside, and if while they're there they need to look around, they can find perhaps illegal drugs. So that would be one. You also have hot pursuit. Hot pursuit is where the police are perhaps at a traffic stop. If a car flees, the individual leaves the car and runs into a house. As long as the police are freshly chasing the individual, they can conduct a search at that point. You also have destruction of evidence. For example, if officers notice some drugs and they believe that if by arresting the individual and leaving the drugs in the particular location they could be taken, the police can go and seize those drugs. You have probably the largest example that I see, or exception that I see, is consent. When an individual encounters a law enforcement officer, if it's a consensual encounter and there's no pressure put on the individual, the officer can ask, hey, do you mind if I search you? If consent is given, then the officer can conduct a search, and that's without a warrant. I think the key to all these is that the police are able to be in the place that they are when they're conducting the search. As long as they have the lawful ability to be where they are, then they can conduct the search without a search warrant.